Thank you. Please be seated. We are here for oral argument on Accursio versus Treehouse et al. It's our number CV-25-0028. Before we get started, a couple things. First, you both know you have 20 minutes. It's there at the podium for you. And counsel, you may reserve whatever time you wish for rebuttal, but you'll have to keep your time yourself. So please begin.
Worse than I thought.
That's okay. They don't start the timer until you start speaking.
I'm not doing good. Good morning, Justices, and may it please the Court. My name is Jill Ormond. I am here today representing defendants BB Group, Mr. Brandt, Mr. Wu, and Mr. Mukunda, which I'll refer to collectively as the BBG defendants in this matter. We're here today to discuss two issues identified by the Court. First is the question as to whether under Rules 48L and 880A6 can a claim for wrongful institution of a civil proceeding be brought. And the short answer is it cannot.
Ms. Ormond, before you get too far, would you mind doing just that and pull that down? I see people in the back straining to hear what you have to say, so thank you.
I apologize. So the first question is whether under Rule 48L and 80A6 can a claim for the wrongful institution of a civil proceeding be based. It cannot. We need this Court to straighten out the difference between absolute immunity and litigation privilege. Through a series of cases, most recently Goldman in 2020, the courts are starting to use the terms, and not just the courts, but also the litigants, use the terms interchangeably. And we need to clarify those two terms. First off, absolute immunity, as presented in Rules 48L and 80A, provide absolute immunity, period, end of sentence. It's
Counsel,
a rare...
may I correct
Yes.
one? Because you just mentioned that we've been using absolute immunity and litigation privilege interchangeably in the courts, and some of the parties do that too. And you just used the term absolute immunity when the rule refers to absolute privilege. Is there a difference between an immunity and a privilege?
Yes. Immunity
Okay,
is...
so should we be focused on absolute privilege here?
Well, as my understanding of the courts are, absolute privilege applies to litigation privilege. They will use absolute immunity, such as Goldman did, but absolute immunity as provided in the rule, hang on just a minute, let me pull up the rule. Let's use that one. Absolute privilege conduct. Apologies.
Well,
It's Rule 80.
I didn't mean to be petty, but
No.
if we're going to be particular about the terms and what import we give to those terms, I want to make sure I understand what you're arguing.
Absolutely, no, and I appreciate the clarification. 80 does say absolute privilege conduct. I've been using the term absolute immunity to be separate from privilege because the privilege confuses issues. Absolute immunity is provided for in Rules 48L and 80A6. It's a rare occurrence, but it applies in very unique situations where the public interest is so vital and apparent that it mandates complete freedom of expression.
Which one of these provisions should we be focusing on, or should we just focus on both and interpret them in tandem? And the reason I ask is because here, I think the bar went under Rule 55, but under unauthorized practice of law, you'd be under, 78
Right.
In there. So it was a little confusing. Do we just leave this up to the bar to decide how they're going to proceed, to decide which rule to closely scrutinize, or do we simply go under both?
And for the purposes of this, I believe all the bar rules can be read together because, and I'm going to jump to the end and then I'll go back. If you look at the Drummond case, and this is where the absolute immunity comes into play. The reason for absolute immunity is, in this circumstance, is public policy demands free reporting of unethical conduct if we're going to continue to enjoy self-regulation. If I'm in a deposition, I see improper conduct, I can't be afraid that, hey, they're going to sue me if I report this. Just as a judge sitting on a bench can't be afraid, hey, they're going to sue me. Now, that's where it turns. Absolute immunity for bar activities, such as bar complaints or complaints on the unlicensed practice of law. Litigation privilege is different, and that's more malleable, because while you still want the protection during a litigation, you have to be free to say something. It's not as absolute as the
And my
bar.
question, I realize really went more towards probably the second issue, at least it has more bearing on the second issue about commencement of a proceeding, but I guess it has some bearing on the first as well, of just which rules are we looking at, because there are different procedures. If you're going under unauthorized practice of law, I think the bar can only, dismiss consent agreement or then file a complaint with the Superior Court. So it's different than when you're going under Rule 55. And so I that's why just procedurally, it's like, where are we focused? Should we just pick it on what actually occurred, which is under Rule 55, or perhaps what was encompassed within the complaint, which is really unauthorized practice of law?
I believe we focus on the rules of the bar separate from litigation rules. So if the statement is, for the unlicensed practice of law, if the statement is then made once it goes, although, I mean, if it's made once it's in actual litigation, but is that Superior Court referral litigation? It's still a bar complaint. It's still under the auspice of the bar and the regulation of the practice of law. And I think that's where the absolute immunity comes in, and that's where the turning point is. It's not this rule or that rule. It's whether we're regulating the practice of law or we're just litigating whose piece of property is this, or whatever else everybody litigates about. So I think, I hope I'm answering your question as far as where I think it's not rule to rule more than what are we doing? Are we regulating the practice of law, or are we litigating a case where we have two opponents?
Okay, if we accept your argument, is the anti-abrogation clause implicated?
No.
If we foreclose any action for a tort that sounds an abuse of process?
No, Your Honor, because we're focused on the practice of law and the regulation of the practice of law. We're not focused on civil litigation and the rights that the anti-abrogation clause provides. We're self-regulating. We have to have certain freedoms to properly regulate ourselves.
Where is that exception in the anti-abrogation clause in the Constitution? Was this right of action or an analog to this right of action available at statehood? An abuse of process?
Yes,
claim?
it was.
So how is it that our rule, as you interpret it, which is intended to advance a policy concerning self-regulation of the bar, how does that exempt its effect from implicating the anti-abrogation clause?
That's a good question, but again, if we focus on while it's available, it was available at statehood, it's not a litigation tool, more of a regulation of the practice.
But if go ahead.
Let me ask you a related question then, because there's some discussion in the Goldman case about that if there's a common law privilege or immunity that existed at statehood, it could preclude the same kind of action then as it could now. Do you have any authority that would identify the type of privilege or immunity we're discussing in the case before us here that existed at the time of statehood?
Not at the time of statehood, no, I don't have that authority. I will say that's where I believe Goldman went off track, where they started conflating the claims of litigation privilege versus absolute privilege that's provided by the rules of practice.
Does it matter the nature of the proceeding itself? Because in Goldman, the court went back and forth between identifying litigation privilege within a judicial proceeding and then saying, but a bar disciplinary proceeding is not a judicial proceeding, but there could be a litigation privilege because it's quasi-judicial, but it's not.
That's what they said, and they got it confused. I mean, they started conflating the issues, and they're not. If we keep the straight lines, this is a bar complaint. This is self-regulation. This is regarding the practice of law, absolute immunity. This is litigation. This is what we do when we write letters in Goldman, when we write letters to opposing counsel, or we submit affidavits, or we submit motions, affidavits supporting motions. That's where the judicial privilege or the litigation privilege comes into play.
Could
Can
you
I-
turn? Oh, sorry, go ahead.
Oh, no. So just talking about I want to focus, though, on the text of Rule 48L and 80 A6, thank you. My eyes are getting worse and worse. That begins the communication to the state bar shall be absolutely privileged conduct, and no civil action shall be, or predicated thereon may be instituted. Why isn't it the absolute privilege refer back to the communication, and no civil action may be predicated thereon, thereon meaning back to the communication? In other words, why doesn't the privilege and the no civil liability refer to the communication, meaning the contents of the state bar charge, the communications within the state bar charge, as opposed to what we're talking about? What happened here was the filing of the bar charge. In other words, why can't the filing of the bar charge be carved out, not subject to the privilege and the immunity here, but rather the privilege and immunity applies to the contents within the four corners, the communications within the bar charge? Why can't we read it that way, those provisions that way?
I think we would if the filing is considered a communication. I mean, any communication to the bar is to fall under this. I don't think they make that carve out. I think anything that is my read of it, I'm looking at 48L right now. My read of it is that if you're communicating, if you're filing a charge, if you're following up during an investigation, and it's not limited just to the attorneys making the charges, it includes investigators, anyone in the bar, referral, or the judges, hearing panel members, settlement officers, whole thing. So that's why it's a practice tool, and any communication in 48L applies. I believe that you can read it that way.
But counsel, let me ask you this. If you were to read the rule that Justice King read as to only pertain to the content of a communication, then you wouldn't need the word conduct. Communications would be absolutely privileged.
True, but I mean, conduct can incorporate any arguments that are presented, any interviews that may be done or conducted. I'm not intimately familiar with how the bar investigates the claims, but I'm going to guess there's interviews of clients or whoever's making the claim. So it would include it would have to include communications for that broader purpose.
Could you turn to the second question? I'm really interested in when the civil proceedings commence in this scenario. And most notably, I mean, when we're thinking about, I mean, as any lawyer knows, man, you get a bar complaint to you, that feels like, boy, this hurts.
Oh,
it feels adverse. So why is it not, and our rules do say commencement of proceedings, things like that. Why isn't it commencement of civil proceedings when someone files a bar complaint with the bar, which then has to go on and do something with it, even if it's just a screening investigation?
Both rules take care to mention the commencement of a bar proceeding. They do not call it a civil litigation. They do not call it a civil action. As far as the UPL portion, or unlicensed practice of law, portion, that can travel to a superior court. But again, it's still part of the bar proceeding. It falls under the bar.
Well, doesn't Goldberg say that what you're really focusing on is proceedings? And so, arose by any other name, whether you call it a civil action, a proceeding, isn't it, the point is that it's a process that is subject to abuse and that people shouldn't be using as if that occurred, as weaponizing it
Right.
for retaliation, that kind of a thing. So why isn't simply commencing a proceeding in that has a process attached to it, commencement of a civil action, at least let's call it that, for purposes of the claim?
Because that's under the state bar's regulation. This court has granted the state bar, or assigned or awarded the state bar the obligation to regulate. If they want to put that measure in place, then there's a rulemaking process or their evaluation of an investigation if they feel it rises to the level of an issue that needs to be brought up. But those are bar proceedings. They're not judicial proceedings.
Can't they end though, I'm thinking under UPL, one of the options is a consent agreement, and that can be, I suppose, anything, but I would think it would be something like, you will not do this anymore. You will refund monies that people paid you thinking that you were an attorney, that kind of a thing. And that can be, I believe that has to be approved by the Superior Court, but nevertheless, is that the ability of is functionally an administrative tribunal's ability to have an adverse effect on a person's interest, legal interest?
And that's not the turning point per the rules that are in place now. The turning point, I mean, yes, any proceeding, any administrative proceeding can have an adverse effect on people. But for purposes of looking at where the immunity lies with the person making the complaint, be it an attorney or a client or what have you. I mean, it's the fact that it's a proceeding to regulate the practice of law in Arizona. And
well, just for purposes of this discussion, assume that we don't agree with your disposition on the first issue,
okay.
and that while communications might be privileged, the actual act of initiating commencing proceedings is not. Proof matters are a whole different deal, but just assume that.
Okay.
So that's why I'm interested in, when does it commence? So here, a bar complaint is filed. Is that commencing a proceeding sufficient? I mean, and I guess you're going to say no. Why isn't it sufficient?
Why no?
Yeah, why isn't it that process something that is capable of having an adverse effect on the lawyer's interest?
For purposes of the issues that we're here for, the adverse effect is not the point of analysis. It's the rules, and bar proceedings are not civil proceedings. Actually, in one of the rules, which I don't have pulled up, but I can supplement, is they refer to bar proceedings, and then they refer to moving it towards civil matters. So even the rules differentiate between the bar proceedings and a civil action.
Counsel, how do you deal with Rule 46H12 and Rule 75B16? Each of those, it says, defines discipline proceeding as any action involving a respondent pursuant to the rules pertaining thereto. That's 46H12. Similar for the unauthorized practice of law, 75B16. Unauthorized practice of law proceeding means any action involving a respondent pursuant to the rules relating to the UPL. It seems that reading those rules, as soon as you file something, that's an action, that's a proceeding, either a UPL proceeding or a discipline proceeding.
But both are bar proceedings. Both are under the bar at that point. They're not in front of a judge.
But it is an administrative proceeding, correct? You
It
seem
is
to concede that. And why doesn't that fall within the reach of Section 24 of the restatement, third of torts, liability for economic harm? Why doesn't, I mean, we generally follow the restatement unless it's contrary to our law, but why wouldn't the bar disciplinary process fall under the definition of that section of the restatement?
Because it's an administrative proceeding, it's not a litigation. It's not, I mean, while the effect might ultimately become economic if an attorney loses their license or if someone is no longer able to pretend and charge clients like they're attorneys, while it might implicate the economics in that respect, you have to go back to the practice of law. What are we doing? We're regulating the practice of law, and that takes precedent over.
But most administrative agencies are regulating something. They're regulating the practice of medicine. They're regulating finance. They're regulating construction. I mean, how is this different?
We're self-regulating. Regulating construction, you have an ROC, you have a board, you have a process. I mean, if let's go to ROC. if a builder, although I have 1 minute left, so I'm going to reserve a little bit. If I'm a contractor and the ROC pulls my license because somebody complained, I can't then go after the customer to say, hey, you made me lose my license. That's what the administrative process and the review process within the ROC is for, is exactly that, because they did a wrongful act.
Thank you.
And I'll reserve the rest.
Thank you. Hey, Mr. Dwyer.
Good morning, Your Honors. My name is Kyle O'Dwyer, and I represent the respondent and appellant, John Accursio. I appreciate the opportunity to discuss with you today these issues that you've designated for us to have this discussion on. I want to start out with the first issue regarding the implication of Rules 48L and 88.6 on a claim for wrongful institution of civil proceedings. As the discussion previously was had, we look at the first step is to look at the text of these rules. What do they say? We have essentially two sentences in each one that mirror each other to an extent. The first sentence of 48L and 88.6 applies to witnesses and complainants and says that there's an absolute privilege. The second sentence applies to the board, members of the board, staff of the board, and indicates that there's an immunity. I think that that language is important, and of course that's the starting point. The law looks at a privilege, which in many instances you have the litigation privilege, which has been extensively discussed and is in the Goldman case and is applicable here. You have the attorney-client privilege, and then you have legislative immunity. You have public officer immunity, which I think is what is granted here to members of the board. And so with those differences, they have to be treated differently. Whenever we look at laws, rules, if language is different for different groups, then we treat them differently. And so that's the starting point with this analysis. And then we also have to keep in mind that in interpreting the rules, we obviously can't interpret them in a way that they would be unconstitutional, such as by violating the anti-abrogation clause. So looking at these, I do believe that in addressing the anti-abrogation clause, because I think it's important, when these rules talk about privileged conduct, no civil action predicated thereon. If we took the BBG defendant's position that meant you can't do anything, then it would be in violation of the anti-abrogation clause, because wrongful institution of civil proceedings claims have been in existence since at least 1267 AD, where we had the statute of Malbridge, if I remember correctly, in England, and came over here, and that's set out in the Ackerman case that we've cited to. And so, as this court's aware, in interpreting privileges, we're not applying new privileges. We can't create a new privilege that didn't exist at the time of 1912 when the Arizona Constitution was put into place.
Mr. Dwyer, I'm sensing by the lack of that many questions about the first issue, I think maybe the court, at least I am more interested in the second issue. So I wanted to move you to that, if you don't mind, unless others bring you back on that first issue. Assuming that we agree with you on the first issue, have you reached the point yet where a civil proceeding has commenced simply with the filing of a bar charge that doesn't go anywhere, that is dismissed? And what I think it was referenced before by Vice Chief Justice Lopez, the restatement 680 and comment B in particular talks about that that can apply, the claim for wrongful institution of civil proceedings can apply. An administrative entity takes an adverse action against the person. And it's been argued that the bar itself can't take any adverse action itself It relies on either the probable cause committee under Rule 55 or the Superior Court for unauthorized practice of law. Do you agree with that, or at least can you tell us what is the adverse action that the bar can take against Mr. Accursio in particular?
Thank you, Your Honor. I think I would.
It's a long-winded
Waiting for
question.
questions, but I was wondering why they weren't. So I appreciate the comments on that and directing me that way. So these rules have different. They have an initial, really broad application. So if you look at 55A, it says bar counsel shall evaluate all information coming to its attention, right? Whether it's a bar charge, ostensibly if a bar counsel is sitting in a courtroom and hears some misconduct in any form, and then make a decision. Now, I don't think that at that point a proceeding has commenced because there's no requirement to respond. There's no action that's going to be taken other than proceed with to the next investigation under 55B, or dismiss it or refer it to another authority. The same is true under Rule 78A, or I guess 78B1. They have that initial screening part that doesn't seem to really implicate rights or bring an action. But after you go to 55B, there are so many procedures and requirements of a respondent that show that this should be interpreted as a proceeding at that point.
So at what, just to clarify, at what point? At the point, so you're saying from what I just heard, it's not necessarily at the time of the bar charge, it's at a later point?
I guess the clarification on that is it doesn't always necessarily come in the form of a bar charge. So if there is a bar charge, that may be the institution of a proceeding.
And I think, my terminology is terrible in this. When I say bar charge, you might have thought you meant by the state bar. What I meant is me calling up the state bar saying, and I would not say this, but Mr. Dwyer is doing something wrong. Violated whatever rule, conflict rule or whatever. So just that initiation, that's what I meant when I said a bar complaint or bar charge.
Sure.
Does that start does that commence the proceeding?
I don't believe that commences a proceeding just because it can just be dismissed right away. And the respondent, the attorney, doesn't have to respond. The bar can just take the information, decide this isn't anything that we need to deal with, and we'll just dismiss it. But when it goes to a next step, when the bar counsel decides, okay, we got this information, this could be unauthorized practice of law, or this could be disciplinary conduct, we need to do a screening investigation. And in that process, the respondent, the attorney, is required to respond to a letter from the bar.
So is it the act of having to involve the person under investigation that triggers, is that the line of demarcation when a response is required?
I think so, because not only is a response required, but the fact that you don't respond itself is a basis for disciplinary action.
And in fact, also imposition of costs, at least under Rule 78, right? Am I understanding that correctly? Under the rules that if the charged party fails to respond, they can subject him or her to depositions, investigative subpoenas, and impose the cost of those depositions on the charged party if he or she fails to participate. Is that right?
That's correct, Your Honor. And in fact, the language is shall impose those costs if it has to go to a deposition.
And who can, and I should pull up the rule, I guess, but who can impose the cost? Is it the bar by itself can impose the cost, or does it have to be a request by the bar to either the court or the presiding disciplinary judge to impose those costs?
I believe it's to the bar. So in that process, the bar counsel requests a subpoena for the deposition. The respondent is able to respond to that and object to it, just having the deposition, because there are costs involved that could be imposed. Then if the subpoena is issued and the deposition is required, then the deposition takes place, and then an additional application for costs, I believe, if I recall correctly, is what is then filed to the committee. And again, the respondent is given, the attorney is given a chance to respond to that and object to it on certain bases, but you're talking thousands of dollars because it's not just the attorney's time, you got the court reporter. To the extent it's unauthorized practice of law under Rule 78, travel costs are included specifically in the rule. And so there are all kinds of procedures that are in place that the Bar Council can use and that are negatively impact the attorney involved.
Well, if that's our dynamic here, under 55A, they can enter into diversion agreements, and under Rule 56A, diversion agreements may include restitution and assessment of costs and expenses. So doesn't that also add into your calculus of when this type of proceeding begins? Because there's an possible adverse outcome even entering into a diversion agreement, or do you disagree?
I do think that that's correct if they do reach out, because they're not required to reach out when they initially intake under the small screening investigation under 55A. But if they do reach out to the attorney and they do come to a diversion agreement, then that could be an adverse action against the attorney.
I'd like to return to an early question of your opposing counsel. So there are significant differences between Rules 55 and 75. You've noted that one is initiated by just simply information being obtained. The other has to be initiated by a charge. Rule 55 pertains to Rule 48A, which denominates it as a sui generis proceeding rather than as a civil proceeding. It seems like the more comfortable fit for a WICIP, if that's how we refer to it, claim would be Rule 78, but it seems like the bar proceeded under Rule 55. What do we do with that, if anything?
Thank you for the question, Your Honor. I think that the rules they're fairly similar. They differ in some respects for sure. But the bar does have a decision, I want to say it's in Rule 74, where it says in an unauthorized practice of law proceeding, they can choose which one. And so if we leave it up to the bar to say, okay, in 78, I'm going to go in 78, it calls it a proceeding, so it's therefore a proceeding. I don't think that would be the right answer because, as we are aware, what we call things isn't necessarily exactly the definition and what we use to determine whether it's proceeding. But I think these rules mirror each other close enough that they can be used interchangeably, if that answers your question.
Counsel, I'd like to go back to the first question for a moment. Most recently in Roebuck v. Mayo Clinic, where we did an anti-abrogation clause analysis, we noted that part of that approach includes looking at whether a plaintiff alleging the same harm could have recovered damages against the same type of defendant at statehood. Are you aware of any authority that would point us to where a regulated professional was able to bring an abusive process claim against someone who initiated a complaint against them within that regulatory proceeding?
I am not, Your Honor. I don't have any case law on that issue. But I do think if we take a step back from it and we look at, well, what is the claim itself, right? A wrongful institution of civil proceedings. My client, an attorney, has a job offer in his hand.
Well, pause you right there. I understand that and the emphasis on the claim and then the elements thereof. But you know, there is a distinction here in part, and I think your opposing counsel was making it in her opening or her argument earlier, that we're dealing with the regulation of the lawyering profession, which is our responsibility pursuant to the Constitution. So we're not necessarily talking about other similar regulated professions that are statutory in basis only. Is that a distinction worth a difference?
Thank you. In my view of it, I think that it isn't different enough, because when we look at the anti-abrogation clause and the cases around it, we're talking about, well, we can't create new privileges, new immunities that didn't exist at the time of statehood. And if you think of, for example, a negligence case in a medical malpractice that is now using this new technology that's out there that was never even close to available at the time of statehood. The bar, the state bar, is a new process, is a process to regulate the attorneys. And I think similarly, with the new technology, we wouldn't be able to abrogate a claim based on the new technology for a negligence claim. Similarly, the state bar, and I don't think it's an exact, the word's escaping me.
Yeah, I mean, it's a difficult analogy to make.
It is.
And the proceedings are not necessarily synonymous either. But as I look at this, you know, there were, beginning back with Drummond, there's a whole line of cases up until we get to Goldman that recognized exactly what the defendants are arguing here. And, you know, taking into account the fact that this is a self-regulating profession, we rely upon attorneys to report misconduct or clients to do that. Are we opening the doors to collateral litigation that could chill someone coming forward with a complaint? You know, and I'm taking about the fact that that 88-6 and 48L also don't provide an absolute immunity to someone who's bringing a complaint. Rather, it's just with respect to the conduct of presenting communications. So, are my fears unfounded?
Thank you, Your
To
Honor.
put a question at the end of that.
I mean, there would be somewhat of a pause that I would say that people would have to think about, okay, am I filing this for the right reason? One thing to think about in Drummond and these prior cases cited by the BBG counsel, those have to do with defamation. Those have to do with tortious interference with contract, not improper litigation conduct like wrongful institution of civil proceedings, like the abusive process case. And so there is a difference, and there is a higher bar in a wrongful institution of civil proceedings case, because you have to, number one, prove that there was process initiated. You have to win. It has to be resolved in your favor. There has to be an absence of probable cause, and there has to be the presence of malice or an improper motive.
Do you win when, does a lawyer win when the bar dismisses the charge even after an investigation and says, we don't think there's anything here? Is that or it's not proven, or that kind of thing? Is that considered a favorable termination if it's not made on the merits?
I believe it would be a favorable determination because it's a dismissal. There would have to be new information, something additional that was brought to the bar's information to bring it again, because the bar is not going to take some credible information, from my understanding, investigate it, and then dismiss it if it believes that there was wrongful conduct.
I'll tell you, the case law, at least on wrongful institution of civil procedure, said that if there's a dismissal of a civil action without prejudice, in other words, it can be filed again, it's not considered a favorable termination for purposes of that claim because you haven't had a favorable determination on the merits. It can come back. It's not done. Similarly, if something's on appeal, it's not done yet. The claim is not accrued. And the reason I ask it is because I'm trying to pinpoint at what point this commences a proceeding. And if I get this correctly, you say it's when the respondent is required to respond, correct?
When they can have some negative action taken towards them. And yes, when they were required to respond, because if they don't respond, that can be subject for disciplinary proceedings.
So that's a good place to pinpoint it. All right. And at that point, a negative action can be taken, and I suppose we just leave to the particular facts of the case whether it's favorable termination or not. We don't need to get to that, in other words. As I think this through, it's a good idea you say, yes, that's true.
Yes.
I want to take you back to Justice Montgomery's most recent question about whether this right was recognized at common law. Under Torres, I mean, the ink's barely dried on that case. We decided about two years ago. And we defined the pertinent right of action as one that existed at statehood in 1912, or that evolved from rights recognized at common law. Is your argument that this right of action for a wrongful institution of civil proceedings in this context is one that evolved from malicious prosecution, which seems to be the father of all of these abusive process sort of torts?
Yes, that's correct, Your Honor.
That was a good leading question.
I like those questions.
But yeah, again, though, if we had new professions that came up now that didn't exist at the time of statehood, would your argument be that, I think this gets to your technology analogy, that new professions start up that weren't recognized at statehood? I don't know if they necessarily would fall within anti-abrogation, because you wouldn't have the same type of defendant who could have been pursued against at the time of statehood.
But I do think you're focused on the harm and then the type of person. Because if it had to be an exact one, and I know my time's up, then it would be an open door to open new professions, new boards that weren't in place, and then we can provide immunity. Thank you, Your Honor.
Thank you, Mr. Dorff. All right, Ms. Orman.
Just a quick point on the civil proceeding versus bar proceeding. I tried to do some quick, find the definition in Arizona of a civil action or a civil proceeding. And what it brought up was actually bar matters that are reported, and they call them bar disciplinary proceedings. So even, maybe if we look at it that way, where you have a disciplinary proceeding versus an actual civil action. And if I recall, I don't have it on the tip of my tongue, but one of the rules even talks about some of the civil rules don't apply, the civil rules of procedure for bar proceedings. Evidentiary rules apply, but it lists out which civil rules do not apply. So I just wanted to add that.
Great. Thank you, Ms. Orman. Thanks both counsel for your briefing and argument today. We will take the matter under advisement and issue an opinion in due course. We stand adjourned for the day.